Assalamu alaikum. Welcome to another episode of Just Law on Ikra TV. And as our regular viewers are aware, Just Law is a weekly program which is a live program in which we discuss and take live questions on air about any issues of English law that you may have, be it criminal law, family law, immigration, etc., etc. And this is a live call show, and there will be a number that appears at the bottom of your screen. Our viewers are requested to call in on the telephone number, ask to be put through, and ask any questions that you may have. Now, because of the nature of the show, because this is a live telephone call show, there may be some times where you may want to ask certain questions, or there may be some private questions that you wish to ask, or not disclose full particulars live on air. In those circumstances, what we've done is we've allowed the opportunity for our viewers to contact the control room, obtain my telephone number, email address, etc., and then you can contact us, and I'll aim to get back to you within a couple of days to let you know the answer. And sometimes there may be a question that you ask that I am unable to answer immediately. Under those circumstances, I will take a name, I will take down details of the question that you ask, and I will aim to answer it live on air the following week. And sometimes when you're asking me questions, if it's particularly regarding your case, there may be the need to peruse through documents, have a look at your specific documents, and then get some further background detail from you. And then it may be the case that due to data protection, etc. issues, we may not be able to answer the question thoroughly, but I'll give a brief overview on live TV, and then you have the opportunity to contact the control room, obtain my details, and ask the questions. Now, our viewers will be aware that my specialty is criminal work, ranging from road traffic to assaults, confiscation, etc., etc. And my main practice is police station representation, magistrates court work, Crown Court work, and the Court of Appeal casework. So if you have any question on those areas, please get in contact with us, and I should be able to answer the question, whatever the question may be, live on air. And insofar as any other areas that you may have, you're more than welcome to ask the questions, and if I can answer it, I will answer. Now, previously we have discussed criminal proceedings, criminal investigations, etc., and I thought it prudent to deal with restraint orders and also confiscation orders. Now, our viewers may be aware that for quite a while now, the prosecution have applied to the courts, and there is legislation which allows them to do so whenever there is an offence which the police or the prosecution believe where the defendant has financially benefited from the conduct, and these are Schedule 2 of POCA offences. And if you are investigated in relation to those offences, then one of two things may happen. Number one, the prosecution may apply for a restraint order immediately upon your arrest or your voluntary interview, or secondly, once you're charged with the offence, then the prosecution may make an application for a restraint order. Now, the question a lot of you will have is, what is a restraint order? Now, a restraint order is an order from the court basically restraining you from disposing of your assets in any way that you would like to do so, and basically your assets will be frozen. So if you have a bank account, it can be in this country or outside the country. If the prosecution come to know about it and you have money inside the bank account, the prosecution will apply to restrain that bank account if you have a property, for argument's sake, a motor vehicle, they can seize the motor vehicle, or they can put a restraint on that vehicle, meaning that you will not be able to dispose of that vehicle. And this applies to all articles of value, all assets that you may have. And the important thing to know is that that applies for assets that are in the country and anywhere in the world. Yes, you've heard me right, anywhere in the world. The prosecution, if they're aware that you have assets or assets have left the country, and then an order can be made to the court ordering you to relocate any of your assets back to the United Kingdom, and for restraint order to be imposed. Now, quite often these follow, and the types of offences that you're talking about is, for argument's sake, money laundering, fraud, drug dealing. So these are the common type of offences that the prosecution normally apply for a restraint order upon. Now, there has to be one of 5 criteria which is passed, and the quite easiest for the prosecution to prove in order to go to the court is to say that we are investigating so and so, and this is an offence of, let's say for argument's sake, money laundering. We believe that this person has assets which include properties, include a Rolex watch, include motor vehicles, etc., etc., and we want to restrain those. Now, the only thing the Crown Court will request, the judge will request, is there a prospect of this person being charged with this offence? Now, the answer, quite frankly, is going to be, if they are investigating the criminal conduct, they'll have to show that there is a prima facie case. So there is a case there in which the defendant has to answer. Under those circumstances, normally the Crown Court judge will rubber stamp the restraint order, and the next thing you know, you'll be receiving an order through post saying you're not allowed to dispose of any assets, you're not allowed to withdraw any money, etc., etc. Now, what do you do in those circumstances? If you're ever issued with a restraint order, sometimes you may be issued for a restraint order prior to ever being interviewed, prior to being arrested. So you'll receive the service of the papers. Alarm bells should be ringing at that stage, because one of the criteria in order to get a restraint order is that you are being investigated for a pocket offence, Proceeds of Crime Act offence. Under those circumstances, the restraint order will be imposed. What you should do in those circumstances is contact a firm which specialises in financial crime, such as my firm. So you'll contact the firm and you'd provide them with a copy of the restraint order, and then provide your personal details to them. Now, what will the firm do? We'll have a look to see whether or not the Crown Court was correct in imposing this restraint order against you, and whether or not the information provided by the police is correct and it was right, and to see whether or not you have been allowed to make use of your reasonable living allowances. Now, reasonable living allowances are different for each person. Now, it may be a case that there's one person and £150, which is the usual figure that the Crown Court allows per week, is okay. It may be a case for another person that even £2,000 a week is less money because of the outgoings that they have. Now, under those circumstances, the Crown Court would have imposed a standard £150 a week living allowance, and then under those circumstances, you will need to instruct a solicitor, and then the solicitor will then go to the financial investigators of the police, whichever police force are dealing with the matter, and then negotiate with them, give a copy of your direct debits to show that you've got X amount of direct debits. These are payments that have been made, and it's not a case that you just made these payments or set up these payments after the restraint order. They've been going out from before. and these are essential payments that need to be made. Under those circumstances, the financial investigators have the power to either agree to the variation being made or disagree. Now, if they agree with the variation order being made, it's quite simple. What will happen is, between the defense and the prosecution, a draft variation will be written. Both parties will sign that document. It will be sent to the original Crown Court judge who made the restraint order, and that Crown Court judge will rubber stamp that variation. The variation order will then go to the relevant parties, and then if it's a bank, let's say HSBC will be notified. Mr. X is now allowed £2,000 per week as a living allowance, so £8,000 a month. And like I say, each case by case is a different scenario. It may be a case that one person doesn't even need £150. It may be another person needs significant amounts of money. So what the solicitor will do, have a look at that and make sure that you're allowed to carry on your lifestyle as it was prior to this investigation against you. Now, there's been occasions where properties may be restrained or vehicles may be restrained, and under those circumstances, once again, just because the property is under restraint order does not mean that you cannot dispose of it. And a vehicle as well is a common misconception. A lot of people believe, or because this property, because this vehicle is under restraint, I'm going to have to keep on to this until the conclusion. It may be a case that either prior to the restraint order being imposed or even post the restraint order being imposed, that you've struck a deal with a person, you're getting market value or even better than market value for the assets. Under those circumstances, once again, you can go to the financial investigator, you can go to the court, make an application to say, I would like to dispose of this asset. However, the caveat will be that the Crown or the court will expect the proceeds from that sale to be placed into a restrained bank account. So one of your bank account will be restrained, and you'll have a living allowance allowed of, let's say, £2,000 a week, and then within that bank account, the proceeds of the sale of this property or this vehicle will go into that. And because that's currently a restrained bank account, the court will know that you cannot take any more than your reasonable living allowance in order to dispose of assets, etc. Under those circumstances, you're allowed to vary the restraint order. Now, it's always important, there's certain banks. I've had a problem recently, Barclays Bank. Unfortunately, if the account has been restrained by the court, then the bank normally says, we're not allowing direct debits. So it's always important to contact your bank if you are subject to a restraint order, to ask them, if we are varying this order by the Crown Court, are you going to be allowing us to reinstate the direct debits from this bank account or not? Some banks allow the restrained restrained bank accounts to be debited on a weekly basis, on a monthly basis, etc. And some say, nope, we only allow you to take a lump sum of cash for your living allowance, whatever that may be. So it's important to always contact the bank first, find out what policies and procedures they adopt, and then contact the court. Otherwise, it's going to be a position where you're still unable to withdraw that money, the direct debits have not been set out, and therefore you're going to have to draft another variation order, go to the court again, which can be time consuming. Under those circumstances, it's always important to conduct your research beforehand, and it may be a case that you seek clarity or seek prior approval from the prosecution or the financial investigators to have a separate bank account for your direct debits, etc. So this is something that can always be negotiated. However, if you have a restraint order, it's always important that you need to abide by the restraint order, and not doing so can result in a separate offence for which you may be fined, imprisoned, or both. So it's always important to abide by those, and if there is any hardship that you're suffering as a result of a restraint order being imposed, and then you can always go to the court, and it's always important to know you can always go to the court to vary the restraint order. Now, our regular viewers will be aware, I have already discussed this, that previously people would be bailed and would be required to re-attend a police station to sign on bail. Now, unfortunately, for some, especially with money laundering type of offences or fraud-related offences, these are time-consuming investigations, whereas bank accounts need to be looked at, witness statements need to be obtained, there's a lot of background information, tax records, etc. So these investigations generally are quite long. So for argument's sake, I've personally had dealings with cases where they've investigated for 6 or 7 years, those people, and the people have been subject to restraint orders throughout that period of time, and it's had to be a case that because their personal circumstances change, they may be unemployed, they may become employed, they may be promoted, they may be demoted, etc. So the financial circumstances will always change. So it's always a case to have a solicitor who specializes in these matters, who is able to negotiate with the financial investigators and take the case to court if the need is. Now, it may be the case that the financial investigator assigned to your case is reasonable and allows the adjustments to be made, or it might be the case that the financial investigator is not interested. Under those circumstances, you'll have no option but to go to the court. And it's always important to have a firm who understands how restraint orders operate and how confiscation orders, etc., operate in order to be able to vary them, etc. Now, that's a restraint order, and a restraint order is normally made prior to charges being made in order to prevent any assets from being dissipated. Now, it's also important that the prosecution can go back 6 years and claw back any tainted gifts. Now, what's a tainted gift? So let's say, for argument's sake, you had a property. That property market value was £500,000, and you decided 4 years ago to sell it to your best friend for £50,000. Therefore, there's a shortfall of market value of £450,000. Under those circumstances, the prosecution will look at the last 6 years, have a look, and if they believe that there has been any tainted gifts, they'll try to recoup the loss amount, because they'll believe that that was done just in order to take the asset off your name and to prevent any confiscation proceedings taking place. Therefore, the prosecution will state that this is a tainted gift that we believe, and there is a shortfall of £450,000. We believe that you was given that money in whichever way, therefore we want another £450,000 from you, in addition to the assets that you have in your name. Currently, there's a shortfall. We believe that these are hidden assets, and we believe that you may have assets abroad, etc. Now, I've already touched on the fact that it may be the case that the prosecution believe that you have assets that have been moved out of the country. Under those circumstances, the Crown Court can make an order for you to relocate those assets. So if it's articles of value such as an expensive watch, or if it's a motor vehicle that you've decided to take to Dubai, for argument's sake, and then the prosecution can apply to the court to say we want to relocate those assets. We're aware by social media records, etc., that this person has been wearing this watch. That watch is worth £100,000, and we believe that that's in Dubai, and you've also got property in Dubai. We want an order to relocate those assets, and an order can be made under those circumstances for you to relocate those assets. And if those assets are not relocated, then once again the court will take the view that those have been sold as tainted gifts, etc., and the confiscation order eventually will be more significant. Now, what's a confiscation order? Now, a confiscation order always follows a conviction. So we've talked about restraint orders. Restraint orders are orders made by the Crown Court in order to restrain your assets until the criminal investigation has taken place, until you've been convicted of offence. Now, if it's the position that you are either not charged for this offence and the officers confirm that no further action is to be taken against you, under those circumstances an application can be made to the Crown Court in order to discharge the restraint order. And by making this application, it will take you back into the position that your accounts were never restrained again. You'll be allowed access to all of your assets. You'll be able to freely sell those assets, use them assets, use your money, etc. And the other option is if you've not been lucky enough to be acquitted of the offence and you've been charged and you've been found guilty or plead guilty to such an offence, then what will follow is confiscation proceedings. Now, what is confiscation proceedings? Now, what will happen is a full timetable will be set up where the prosecution will decide what your benefit figure was. Benefit figure means from this particular criminal conduct, and if we stick by fraud, for argument's sake, if the fraud was £100,000, then your benefit figure from this specific criminality was £100,000. Therefore, it's the prosecution's task to recoup £100,000 from you. But in doing so, they'll have a look at your assets and they'll dissect your bank accounts, etc., for the last 6 years. And if it transpires that there's unexplained amounts of assets or money going in, then they'll add to that benefit figure, and then they'll come to a benefit figure, and then they'll come to an available amount. The available amount is taking into consideration all of the assets that have been restrained. So if you have £100,000 as your benefit figure, £100,000 as your available amount, then that'll clear it. If your benefit figure is £100,000 and if your available amount is £50,000, the prosecution will seek to recover the £50,000, and then you'll have a period of time which will be set by the court in order to pay the remaining £50,000. And if you do not pay that within the specific time, then you will serve a sentence in default. Now we're going to go for a short break, and after the break we'll go into a bit more detail regarding confiscation order. I'll see you at the other side of the break. Assalamu alaikum.